Judge Glacier, I just want to let you know that it looks like we have representatives for all parties as well as the court reporter ready when you are.
Great, I'm ready. You can bring them on in.
Good morning, Judge.
Good morning. Good morning, Council. Good morning, Ms. Roberts. Nice to see you again, Ms. Roberts, and nice to see you, Council.
Sorry I'm late. I'm running from an 8 o'clock dental appointment.
Oh, are you okay?
Yeah, I had to get 2 caps and I got my teeth cleaned. So
Oh,
it was gonna be kind of tight, but I get here not to make you all wait too long.
I'm glad you're okay. You know, you never know how long those appointments are going to take.
So I called ahead of time because I knew I had this meeting. I called yesterday. I said, I got to be out of here by 11:10 because I got a meeting on Zoom. I got to get out of here. So they said they'd get me out. They did.
Oh, well, that's good. Well, I'm glad you're here. And good morning again, everybody. Let me call the case and then you can put your appearances on the record. We are here today in City of Grand Ledge versus Michigan Department of Environment, Great Lakes and Energy. Court of Claims docket number 21-209MZ. Council, why don't you put your appearances on the record?
Your Honor, thank you. Charles Barbieri and Mark Kerner, counsel for the plaintiff, City of Grand Ledge.
Good morning, Your Honor. Jillian Wenner here on behalf of EGLE.
Thank you for coming this morning for this hearing, which I don't expect will take too much time. We are here to talk about the plaintiff's motion for a speedy hearing. And I wanted you to know that I've read everything. I've read the complaint, I've read the answer, I've read the motion, I've read the response. And I still remain a little bit confused about what the plaintiffs mean by a speedy hearing, how speedy, and it would seem to me that some discovery is needed here. So I'm not sure that a hearing is really what you want. It seems to me you want a trial, but my sense is that a trial is going to require some factual development, but let me just throw that out there to get the ball rolling and you can take it from here.
Thank you, Your Honor. Again, Charles Barbieri, one of the attorneys for the plaintiff, City of Grand Ledge. This matter has substantial public importance for the city and its citizens, which depend on a public water supply and a well field that's been in existence for a considerable period of time. And it's reached a stage where the future of the water supply hinges on the utility of a well that was developed some time ago. We're asking today that the court advance this matter for expedited review based on the premise that the decisions that had been made previously, in our view, affirmatively, now no longer exist. And we seek a court declaration that the production well number 9 was part of the baseline capacity intended under Part 327 of the Natural Resources and Environmental Protection Act, and then that a variance from the 200-foot isolation zone has been approved or recognized historically. We submit, Your Honor, that the type of hearing that we're seeking is whatever needs to be decided. And if that includes some trial testimony and record, we would include that as part of this request. Specifically, we were going to suggest to Your Honor that this matter be advanced with a suggestion of only 60 days of discovery, such that if there is anything missing or not entirely available to either side, that that could be obtained in a expedited manner so that this matter could be presented to your honor in whatever form that it would be in for decision. There is obviously some possibility that we have disagreements on some key conclusions here, and the court may value the testimony on some of those points. Our concern is if the discovery is long and prolonged, that we are having justice denied because of justice delayed. And we submit to your honor that the arguments that they have made in contradiction to ours don't warrant the use of the normal discovery form that apparently they're recommending or seeking. Specifically, they raised two arguments. One is that we have to show good cause. I don't believe we have that requirement specifically in the court rule issue here. That's MCR 2.605. What we do have is a demonstration that we have a firm capacity that is based on a maximum daily demand, and that once it reaches an 80%, which we believe will occur in the not so distant future because of growing projections in the city of Grand Ledge, that we need to have a decision on this now because there are no other alternatives other than expensive ones at a considerable expense. For example, we indicated to your honor in the pleadings you probably have already seen and in our motion that the alternative would be about $24 million at the very least, and we believe that's somewhat conservative given the value of some alternative land that might be otherwise available for a public water supply. Because of the matter being of such significance and because of the growth that the city expects, we believe that there is demonstration here that this matter should be advanced without having an additional good cause requirement being imposed here. The other argument they seem to be raising is that we didn't seek a Part 399 permit. And I will acknowledge that that Safe Drinking Water Act permit is not being sought at this point in time. It's incumbent upon us to overcome, I believe, two hurdles before we can go to that. And that is, by the way, a very inexpensive proposition. Going to the Part or Act 399 application, which requires full design documents, including sealed and signed engineering plans, would cost in the neighborhood of $500,000 plus. So it's not a light venture on our part to take on that. But before we get to that point of seeking that permit for the pump, we want to clarify that by a declaration from your honor that we do not have to demonstrate that public well number 9 is provided and meets certain Part 327 water withdrawal requirements. We believe that this well was in existence back in 2006, should be essentially grandfathered in, and doesn't require the lengthy and costly demonstrations that a Part 327 application for water withdrawal would otherwise require. We also submit that that well was placed and positioned and with the understanding that it would not be subject to 200-foot isolation zone requirements. And again, we're seeking a court declaration on that.
So wait, let me stop you for a second. If you get a court declaration on that, does that mean that you're then relieved of the requirement to get a permit under 399?
No, Your Honor, we would then have that requirement to make, but that eliminates two procedural hurdles if the court makes that declaration so that we can advance those particular items onto the department. We have not presented it, as I said, because it's a rather costly venture. We would be able to do so upon a court decision. and move forward with the activation of production well number 9.
All right, Ms. Wenner?
Morning, Your Honor. Eagle's arguing that this court should deny plaintiff's motion because it hasn't shown any need for immediate resolution of this case, nor up until this point has it defined what the appropriate speed would be. Plaintiff never states when it expects to be harmed or how these two questions hinge on the harm that it expects to experience. The harms that it describes in its brief are related to this Act 399 permit to equip the well for production that it's never applied for in the 20 years since the original test casing was installed. It's also not addressed its own lack of urgency in attempting to equip this well with production equipment and obtaining that permit. Further, that permit can't be issued through this declaratory judgment suit. And even if these questions are resolved, when they will submit a permit is not something that they described in their as urgent, I suppose. But as a practical matter, when the plaintiff filed this motion, it did so without defining that timeframe that it sought for hearing of this case. And when you requested, Your Honor, that the parties work it out, they also never proposed the schedule that they are now seeking. Despite it being their motion, I did propose a schedule, which they've rebuffed. But
What is the schedule that you've proposed?
Last year before Judge Murray, I had a similar case. So the schedule that I had proposed would be that witnesses, including experts, shall be named and exchanged no later than August 15th, 2022. Discovery completion on or before October 24th, 2022. Motions to amend pleadings by September 5th, 2022. Dispositive motions no later than October 31st, 2022.
Okay. Let me tell you what, the court's going to deny the motion for a speedy hearing because I agree with Ms. Wenner that there hasn't been a showing that there's any emergency here or that there's any event that will occur that will put the water supply in danger. That showing just hasn't been made. And I view this in some ways as a procedural effort to get around what ordinarily would be a motion for a preliminary injunction or a TRO, which would require a certain evidentiary submission regarding urgency. So I just don't see it here. That said, the Court of Claims is a very flexible court. We are able to accommodate you, and we want to accommodate you and the needs of the litigants as much as possible. Ms. Wenner, are you anticipating bringing a motion under C8 just based on these pleadings? I'm getting the sense, and I'm not suggesting anything, believe me, this is an area that's really far out of my legal comfort zone anyway, so I apologize if my question is awkward or bordering on the ridiculous, but it would seem to me that you have made or begun to sketch out an argument in your pleadings that this is not a justiciable controversy at this point from kind of an administrative law point of view. And I don't know if I was reading into the pleadings or your argument, or if that's really something you want to pursue, but let me repeat the question with that background. Do you anticipate bringing a C8 motion that would arise based solely on the pleadings and not on any discovery?
Yes, we do.
Okay. Well, let's get that scheduled because I think that, getting that scheduled on an expedited basis is reasonable. The state has now had, this case was filed in the fall, October or
November.
October, November. So you've had a few months to digest the complaint and to think about how you are going to respond. If the court were going to enter an order requiring that your motion for under C8 be filed in 28 days, is that doable?
Yes.
Okay, well, that will be the court's order that your C8 motion has to be filed within 28 days. How much time are you going to need to respond, Mr. Barbieri? Because I'll give you, if you need more, I'll give you more than the court rules. You know, the court rules say 14 days. Our court rules do. But you can tell me what you need.
I believe 14 days would be reasonable, Your Honor. And if I felt differently, I'm certain I'll talk to Ms. Weiner about it before we bother Your Honor.
Yeah, I mean, I'm you know, as you probably already know, I'm completely flexible. I want to do what's best for the lawyers in terms of giving them confidence that they're making the best presentation possible before this court. So what it takes, it takes. Okay, so if we set a deadline for the filing of a C8 motion in 28 days, a response in 14, the court will decide it very quickly thereafter. And then what I'm thinking is that at that point, once the court decides the motion, if it's denied, we will have a relatively immediate status conference, scheduling conference to see where we are. I mean, it's possible that the motion may narrow the issues. It's possible that the motion may suggest to me that we really don't need that much discovery. I mean, the motion will be very helpful to the court in that I'll get a sense of what's truly at issue here, both legally and factually, I think. The motion and the response will anyway. So that will allow me, I think, to make a more informed decision regarding scheduling. I hope that makes sense.
Your Honor, in light of your comment, we had been previously requested to submit a scheduling order. I would assume then we're relieved of that responsibility at this point.
Yes, we will reconvene when the court decides the motion, the motion that Ms. Winter is going to bring. If it is not granted, so if the case survives, we will then, and I have no idea, believe me, I am not projecting anything or predicting anything. As I said, this is a totally new area I'm wading into here, so to speak. So we will reconvene though shortly after the court decides the motion, if the motion is denied. And at that point, we will craft together a scheduling order that allows you to have as swift a determination of the issues that remain as possible.
Thank you, Your Honor.
Okay. Any questions? So my order is just going to state, I'll prepare the order and it will just state the two dates that we've sketched out, and that if the motion is denied, that the court will supply a date for another scheduling conference. Okay.
Understood.
And I'll contact you, the clerks will contact you regarding the date for that scheduling conference. So I won't pick a date out of the air. Okay. Any questions or anything else you want to bring to my attention at this point?
Not from the plaintiff, Your Honor. Thank you.
Sure. Ms. Winter?
No, thank you, Your Honor.
All right. Hopefully you'll get the order later today. So if not today, you'll get it tomorrow. So, all right. Have a great day, everybody. Thanks for coming.
Thank you.
Bye.
And someone send me I got on kind of late and I usually take a picture of the caption that they have up there. Can someone send it to me, or can the lady put it back up there?
You know what? I can have Morgan. Morgan, are you still on? Is Morgan still with us?
I am, and the slide presentation that you're talking about will come back up after this.
Okay.
Okay.
Or maybe you could just even email Ms. Roberts a copy of the caption. Whatever she
We can do
needs.
that.
Does
Okay.
anybody need a transcript?
I don't think so.
You don't need this transcript? Okay,
Okay.
All
Thank
right.
you.
Thank you. Bye-bye.
Thank you. Thanks again.